Hi, my name is Lou Dangs Allen, and I'm an immigration lawyer coming to you live from Toronto, Canada. Thanks for attending our webinar entitled Study Permit Refusals, What to Do. I know that we have a lot of participants coming in from Manila, the Philippines, and I believe it's 8 p.m. over there today, so good evening to those participants. And please feel free to type your questions in, and we'll try to answer them to the best of our abilities during the question and answer portion. So without further ado, let's begin. So this presentation is going to be divided into two main sections. First part would be the reasons for refusal, and the second would be your appeal options should you be refused a study permit. So moving on to the first slide, which is the reasons for refusal. So what are the common reasons for refusal? The three main reasons that we usually see when someone is refused a study permit when applying for a study permit to Canada would be lack of funds or lack of proof of funds, lack of concrete study plans, or lack of logical, coherent study plans. There's also the possibility of getting refused in the push and pull analysis. What that means is that people who are not as attached to the Philippines or to their home country and have significant attachments to Canada would not pass this test because there would be a strong push to go to Canada, and then there would be weak pull ties to the home country. So that, in a sense, would convince an officer that you may not necessarily leave Canada at the end of your period of authorized stay. So the question is, when you get refused, what do you get from immigration? So, as you can see in the slide before you, you will get a boilerplate letter containing template reasons with respect to the decision rendered against you, which is a refusal. This example is interesting because it basically outlines the basis of the refusal, which is Section 216 Sub 1 of the Immigration and Refugee Protection Regulations. And what it says specifically is, I am not satisfied that you will leave Canada at the end of your stay, as stipulated in subsection 216 of IRPR, based on the purpose of your visit, based on your current employment situation, and based on your personal assets and financial status. So those are standard boilerplate reasons, but these are not the real reasons. And if you can see before you, the next slide shows what's called a GCMS information request, or the GCMS Notes. GCMS stands for Global Case Management System. So the GCMS is what Immigration, Refugees, and Citizenship Canada uses to manage applications globally. And in those notes, you will see an officer's reasons or the basis, the exact officer's notes for refusing an application. The example in front of you is quite telling, in fact. So in this particular situation, if I'm going to read directly from the example, length of study is 6 months of study with 6 months of co-op for a total of 1 year. Applicant is blank years old with a bachelor's in nursing from blank university. Applicant did not submit any financial support documentation. Tuition and support as indicated by the applicant is to be provided by blank, parents and godparents. No proof of funds or any supporting documentation submitted. Weighing the factors in this application and the complete lack of supporting documentation, I am not satisfied that this applicant is capable of supporting himself or herself financially during the period of proposed study in Canada, and as such failed to establish that they are a bona fide temporary resident who will leave Canada following the completion of studies pursuant to Section 2161B. So that's the infamous section in the Immigration Refugee Protection Regulations that is usually the basis for refusing an application on the grounds of not putting enough documents or not putting the right documents and not establishing what's called the bona fide factors of an applicant. What does that mean? It's just Latin, and it's fancy for saying that you're a genuine student, that you are genuinely intending to study in Canada. So in this particular situation, the officer decided to refuse the application because there was incomplete documentation, and on balance, weighing that with the fact that the application was not complete and properly done, then they have enough basis for a refusal. So, how do you get access to these notes? That's a really good question, and that brings me to my next slide. So, an ATIP request, or an Access to Information Program request, gives you access to the Global Case Management System notes. This request can only be done if you're physically in Canada as a person, or you can get a Canadian citizen or permanent resident to actually ask one for you. So, say for example, you're not a Canadian citizen or a permanent resident and you're not inside Canada, you cannot apply for these notes. You would have to get your friends and you would have to consent for it. There are some companies that actually specialize in procuring these notes for you. Generally, immigration law firms such as this one, we do it for our clients on a regular basis. So if you've been refused, don't be shy. Reach out to us and we'll be able to pull out these notes for you. So moving on to the next slide, what would be your appeal options when you do get refusals and when you do have your notes, the officer's notes, as reasons for the refusal? So generally speaking, there are 3 appeal options, and I use the term appeal very loosely here. They're not strictly speaking appeal mechanisms, but rather, just colloquially speaking, they are a means of like trying to reverse a decision. So these would be reconsideration, or a request for reconsideration. The second would be a reapplication, and the third being a judicial review application before the Federal Court of Canada. The first one is essentially asking the same officer who refused your application to reconsider the application. The second one, reapplication, is to submit a fresh application. And normally these boilerplate or template refusal letters, they will contain a paragraph that will invite you to reapply if you think that you can address the issues that they are raising against you. And finally, the judicial review process. It's a court process wherein a court would look at a decision, an administrative decision in this case, if it's lawful, if it's reasonable, and if it's fair. So we'll dive into each one of them in detail. So the next slide specifically deals with reconsideration. So as I said, it's asking the same officer to revisit the decision. Now, in these situations, there is a clear error in fact, or in legal terminology, it would be unreasonable. Or it could be that the law was improperly applied to your set of facts. So that would be a correct, it would be an incorrect decision rather. So for example, the officer may have neglected to review a certain set of evidence that you included in your application. For example, you may have submitted a copy of your bank statement and the officer in the reason says that they didn't receive any bank statements. So that is a clear error in fact, and that would be unreasonable. And you can ask and point it out to the officer that, hey, how come you said that I didn't submit my bank statements, wherein in fact it's actually there? Please review and reconsider. So in those cases when it's very, very clear that they made a mistake, a lot of times these officers, they're also human, they will admit to it and they will correct their mistake. I would say that you should only do this if the error is really clear on their part and it's in your favor, obviously. The big disadvantage to doing a reconsideration application is that, number one, your window period in making that application for a request for reconsideration is very, very small. But the other thing about it is, number two, that officers generally don't like revisiting decisions that they rendered, probably because it hurts their stats. It's a professional issue on their side. But usually they just find other reasons to refuse your application if you do point out that they're, that they neglected to look at a set of evidence that you submitted. So for example, going back to that example that we just mentioned a while back, if the officer missed your bank documents, they could come back with a negative decision still, saying that, well, you've not convinced that officer that you would leave Canada at the end of your period of authorized stay. Generally speaking, they don't like reversing their decisions in a reconsideration, request. So that brings me to my next, to the next mechanism that's available for you. That would be a reapplication. So what is a reapplication? Now in this slide, it says that essentially, it's probably the fastest option for you. And essentially, it's a fresh application. And in this application, you may choose to address the specific issues that an officer raised in your previously refused application to get, hopefully, a positive decision this time around. So in this particular situation, why I say it's advantageous and why it's fast is because the alternative would be to fight them. And remember, in the template refusal letter that they usually send out, they specifically say that you may choose to reapply. And that's usually how they like to do it. But there are disadvantages. If there's a long queue for the application, if there's like a long processing time, you'd be at the back of the queue. But generally speaking, it's still the fastest because your alternative would be to basically file for judicial review at the Federal Court of Canada, which brings me to my next slide. So what would be a judicial review? So in certain cases, this would be your best option, especially if you don't want a refusal record on your permanent file with immigration. And this is essentially a court proceeding with the Federal Court of Canada that reviews an administrative decision. And one of the classic examples of an administrative decision would be a visa application. In fact, a huge chunk of the Federal Court of Canada's work is centered on immigration decisions. A judge determines whether the decision was reasonable, correct, and fair. So, as I said, there would be standards for review, and I won't go into the, detail of it and won't bore you, but there are two standards, generally speaking. That would be of reasonableness, and usually this is on the appreciation of evidence. So these are usually evidence and fact-based questions presented before the court. And then there would be correctness. And correctness is if the officer misunderstood or misinterpreted the law that would be applicable in your particular situation. Or there could be a procedural fairness issue. For example, you were not heard. You were not given the right of reply when they were attacking your credibility in the evidence. For example, if an officer alleges that you have submitted fake documents, then that would have been a form of misrepresentation, but then they didn't give you a chance to respond to that. That would be a question of procedural fairness. Now, I should say that the interpretation of evidence is very, very subjective, and depending on the prevailing interpretation of the law, you may have a decision reversed. Now, courts generally defer, or meaning they give way to the decision maker, because decision makers are generally closer to the evidence versus a judge who's sitting in a bench and can only read the evidence, and they're restricted to the record of evidence presented before them at the judicial review hearing. So, as I said, the advantage of a judicial review is that basically, compared to a reapplication, you won't have a refusal history. And for some people, this is very important. It's kind of a scarlet letter that will follow you for the rest of your life if you have a refusal from one country, because generally speaking, other countries ask if you've been refused a visa. So if you've been refused a visa in Canada, that'll follow you. And then another advantage would be is that if you have a strong case, and let's say you submit or file an application for leave for judicial review at the federal court, and you have a very strong case, as I said, there's a possibility that the Minister's Counsel at the Department of Justice in Canada could receive instructions to actually settle. That means that they could offer to basically resolve the court case and dismiss or discontinue the court proceeding in favor of having the application reopened and be assessed by a different officer, for example. So that is a huge advantage to judicial review application because it could expedite the reopening of a file instead of actually having to refile a fresh application. And for those who want to maintain a perfect record of not having a visa refusal, this is a very important consideration. Now, one other aspect to that is because GCMS notes are very hard to get lately because of COVID. What's a big advantage is that if you do a judicial review application, the government is bound to release the reasons, the real reasons, not the template reasons, to you within a certain number of days, as prescribed by the rules of federal court. At the moment, immigration says that standard processing time for GCMS notes processing through an ATIP request takes about 365 days. Granted, most applications that are restricted to electronic note search are processed very quickly compared to a search for paper records, for example. And this is due to COVID, obviously. So the advantage to that is that if you do a judicial review application, by rules of court, or the federal court in this case, the immigration department will be compelled to release the reasons right away. And we've done this a couple of times over the last few months in order to actually get the notes in view of the fact that processing times for GCMS notes for our clients are very slow. Now, in certain cases, the Department of Justice in Canada has offered to settle out of court these applications, and they've remitted the decisions back to the Visa Application Center for re-adjudication. They've reopened the file so that someone could actually decide on it again and properly this time, versus someone who we assisted and we got the reasons, and what we found was that the applicant did actually forget to include certain documents. And in that situation, we recommended that we resubmit an application and do a reapplication and do everything properly this time, along with addressing the officer's concerns about genuineness aspects of the application. So we've asked our friends over on Facebook a few days ago if they had questions that they wanted to ask during this webinar, and we did get some really interesting questions. So I'm going to try to answer them. So the first one, diving into the first one, is what are the usual reasons for refusal? So I've outlined 3 of them. The first one being the lack of funds. The second one is a lack of concrete study plan. And third is push versus pull analysis. So I'm going to go into detail into each of them, and let's start with lack of funds. First of all, sometimes people forget to include proper evidence that they have the funds. I know specifically for the Philippines that a lot of people tend to submit just a bank certificate or maybe a bank statement, but just for the last 1 or 2 months. That's not enough. Specifically, Manila asks for 6 months of bank statements. So you have to, from the time you're applying, you have to pull out your bank statements from 6 months from that point and include that in your application. So on that basis alone, in fact, I've seen officers refuse. It's very rare, but I have seen them refuse applications on that alone. They don't need much. If you don't comply with a requirement that they're setting, then essentially you're going to end up with a refusal. They do have a checklist, and if you're doing this online, it's not the checklist that's generated on your GC Key account. For those who don't know, a GC Key account is a Government of Canada key account that allows you to apply for visas and study permits, work permits, etc. on the internet. So what it is there is a Manila visa office specific checklist, and it does say in that checklist that you have to submit at least 6 months of a bank statement. Now, the amount that you would need to show that you have depends on your size and the size of your family. So if you're studying alone and you're going to Canada on your own, and you have no family that you will have to support while you're studying, the base minimum for funding requirement would be $10,000 Canadian that would be available to you in liquid assets, meaning that it has to be something that you can liquidate easily. So it could be in the form of investments, so long as you can easily access them. Say, for example, mutual funds that are invested in banks. But there are certain investments, such as treasury bills, that could be, not liquidatable right away, and immigration may not necessarily accept that kind of proof, of funds. Now, the funds have to be readily available, as I said, and this has to be balanced with the tuition cost. So, generally speaking, I tell my clients to make sure to pay at least one semester's worth of tuition. If they can pay the entire year, that would be great because it does help on establishing that you're very serious about studying in Canada, but it also offsets the need to present a bigger amount than the minimum. Because you can easily say that, well, I have the minimum, but keep in mind, I've also paid for my entire first year's tuition. So that helps a long way in the adjudication of visa applications. I would say, as a final note, with respect to lack of funds, to refer to the IRCC guidelines. Uh, the IRCC guidelines on their website they do have a table that tells you how much money that you have to have accessible to you depending on the size of your family. The rule of thumb is 10,000 for one person. If your spouse or common law partner is coming with you, it's going to be another 4,000, and for each dependent, it's going to be $3,000. And we're talking about dependents under the age of 18, of course. Now, the second typical reason for refusal would be the lack of concrete study plans. And this isn't unusual, considering that this is a very subjective test. Although there are certain things that you need to keep in mind when you're doing or when you're writing your study plan or your statement of purpose. So, first of all, your application has to have logical coherence. It means that you have to write logically, meaning you need to write something that makes sense. And in order to make sense, use simple English. I've seen a lot of people who write their statements of purpose as if they were writing for a declamatory contest. This isn't that kind of contest. You're looking at an officer. You're probably going to get an officer who's tired, who's read so many applications, and it's like 3:30 in the afternoon. If you send them something complicated and something hard to understand, you're not helping yourself. You're probably going to annoy that officer and raise eyebrows and you're not going to help yourself, and you're probably just going to hurt yourself. So be very careful with what you write. It has to be logical, it has to be clear, and you have to factor in the fact that you may have had previous education, and how does that actually balance with the kind of education that you're going to get into Canada? How does the education in Canada balance out with your current career, with your study objectives in order to further your career or maybe change careers? You have to explicitly explain this, or you have to clearly and coherently explain this in your study plan or statement of purpose. One of the other things that would be interesting and that I typically advise my client to take care of in their study plan would be their prospects of employment after taking that program of study or whatever business plan that they may have. So that's something that establishes the coherence or rounds it up essentially to answer the why question. So the short version of this is that you need to address the why are you studying in Canada. This is the essential question in this particular requirement, and if you're not answering the why, then you should expect a refusal. And finally, there's the push and pull factor, which is essentially a question about if you have strong pull ties to the Philippines, for example, if you have commercial interests or business interests in the Philippines, if you have shares to a corporation, if you have a business that you're leaving behind, if you have a job to come back to, if you have properties, for example, those are the things that actually pull you back. Conversely, there are things that may pull you to Canada. So, for example, if you have siblings in Canada, and that would be something that could pull you to Canada and convince an officer that you may not necessarily want to leave Canada, and you might not necessarily adhere to the conditions on your visa. So you need to be careful when when establishing your intentions. So in this situation, this is more of art than science. And it's very tricky because you have to factor in how you would present your evidence without obviously lying. Do not lie to a visa officer. That would be misrepresentation. but you have to essentially package your information, to package your intention, declare your intention in a coherent and logical way that essentially balances your push and pull factors. So this is highly discretionary, and the judges generally would look at these things. If you appeal it or have it judicially reviewed at the federal court, they generally defer to the decision makers at this particular instance. So in the push and pull analysis, I should mention that there are two things that they generally look at: family and material ties. So the typical question would be, is that if you have family in Canada, are you leaving family behind in the Philippines? Or do you have enough economic, financial, business establishment in the Philippines, even professional establishment via employment prospects? Do you have a job to go back to, for example? Or after studying in Canada, disrupting your professional rhythm, for example, is there something that you're going to go back to? And are you financially independent? These are the things that are used in the push and pull factor analysis. So moving on to the second question. The second question is help. I received this refusal letter. What should I do? And I believe I already showed this earlier in the previous slides. And in this particular slide, it shows the templated response or template decision from immigration. And these are generic, and they do not generally provide the real reasons for refusals. And this is why it's important to order your GCMS notes. So what should I do? As I said, this is a boilerplate letter, so you need to get the real reasons, and you have to do an ATIP request or a request for your GCMS notes in order to actually get a glimpse of the reasons for refusal. So in this situation, you would have options once you see your reasons, once you see the officer's reasons. And if the reasons are, let's say, reasonable, they make sense, then you might as well just reapply. In this particular situation in front of you right now in the slide, it says that the person did not provide enough documentation. In those situations, you really are out of luck. My recommendation in this particular situation is just do a reapplication and address the specific issues raised by an officer. And then that's the end of it. So moving on to question number 3 is, what should I put in my statement of purpose or study plan? So the answer to that is it's more art than science, as I mentioned earlier. You have to essentially establish your intention and answer the why question as to why you want to study in Canada and how is it going to benefit you. I've seen study plans or statements of purpose that were poorly written and resulted to refusals. There is a tendency amongst applicants to essentially just narrate their credentials. That's not what immigration wants. They want to understand why you are applying for a visa, why you are applying to study in Canada to begin with, in order to establish your intentions. They need to understand your motivation for studying in Canada. If you just narrate your resume, that doesn't help. And unfortunately, a lot of statements of purpose that I've seen that resulted to refusals do tend to be like that. So as a result, I would refer you to a set of guide questions that, in fact, immigration doesn't really put this on their main website, but if you check into one of their visa offices, specifically Abu Dhabi, you'll see that they've posted some questions, sample questions that you'll want to answer in your study plan. And these are, why do you wish to study in Canada in the program for which you have been accepted? And as I said, why? That is the primary question, isn't it? And then, what would be your overall education goal? Next, why are you not pursuing a similar program of study in your country of residence or citizenship? So what's the advantage and why Canada? So apart from why do you wish to study in Canada at that program, you also have to answer why in Canada. The reasons may be personal, but immigration needs to understand it and need to peer into your mind to understand why they should give you your visa. They can't just, logically connect the dots. You really do have to spell it out for them. Some other questions that I like would be, and I've not included into the slide, but I have put it in my notes, is how would the program of study enhance your employment opportunities or your business interests? And what ties do you have to your country of residence, for example? I do like it when my clients, for example, mention that they have family back home that support them lovingly and provide financial motivation and motivational and emotional support for them, and that they will be visited while they're in Canada. So stuff like that, they do go a long way because it adds detail into your study plan and shows your intention to be an international student. And lastly, I would also add the last point. So why not study in your country of citizenship or country of residence? And I know I've already mentioned that earlier, but this is very important. What I would recommend in this situation is, pull out a program, a similar program in your country of origin, and explain to an officer why this is not a fit with your particular plan. Because if you can establish that there is a program, and this is the most similar program that exists in, let's say, the Philippines versus the program in this college in Toronto, then, you're not just comparing, abstract things. You're comparing actual things, perhaps with program descriptions and even a course list. And the officer would be aided greatly. You're helping the officer in understanding that, oh yeah, that's true. These programs are very different, and I can see why this is very advantageous to the applicant. And hopefully with that, you'll get an approval when you establish your intentions properly and you submit a proper and complete application to immigration by exercising your 3 appeal options should you get a refusal. So I think that's all the time that we have for today. What we'll do is we'll post a 10-minute follow-up to answer your questions. At this point, unfortunately, we run out of time. So thank you very much for attending. And if you have any questions or if you would like to book a consultation with us, please go to ljd-law.ca where you can actually click on a button that says free assessment. No strings attached. Go ahead, guys, and just get your assessments done if you want to move to Canada as a permanent resident, or if you want to study and see what options you have to come to Canada as a permanent resident. With that, thank you very much and have a good night, everyone. Bye-bye.